The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. And good morning. We have 3 cases that will be submitted. Those cases are as follows. Guillermo Hernandez-Ruiz versus State of Iowa. Second case is Laverne Edward Belk versus State of Iowa. And the final case is Kelvin Franklin versus State of Iowa. Those last 2 cases are now submitted to the court without an argument, and we'll proceed to hear the arguments in the Hernandez-Ruiz case. Mr. Ogden.
Good morning. May it please the court. The defendant's Sixth Amendment right was not violated by advice that he received from his privately retained immigration attorney. The district court's grant of his post-conviction relief application was based on a legal error. That is, the district court held that regardless whether the Sixth Amendment right had attached, the fact that he had an attorney meant that he was entitled to the effective assistance of that attorney. Both the United States Supreme Court and this court have held that the right to effective assistance of counsel is the right to counsel. They're the same claim. You see that in the Wainwright versus Torna case, Pennsylvania versus Finley, and also from this court in State versus Dudley and others. And that makes sense because, as the Supreme Court said in McMahon versus Richardson, the right to counsel is the right to effective assistance of counsel. You can't be denied a right to counsel through your attorney's behavior if you didn't have that right in the first place. Now, the district court did address the state's argument that the right had not attached, and it relied on a lone federal case that was decided in the United States District Court for the Western District of Pennsylvania, United States versus Bowers. Now, Bowers was involved a sort of a sweeping prosecution of financial crimes involving multiple people, and it involved an attempt by the United States attorney to obtain the cooperation of a counseled person of interest, that was Marie Bowers.
Maybe you'd answer this question for me. In Iowa, under the Iowa Constitution, when does the right to counsel attach?
The right to counsel attaches at the earliest after Green once there has been a firm commitment by the state to prosecute. Now, with that said, I would like to just point out at the beginning that I don't think that that any Iowa constitutional claim is present before the court in this case. In his application, the defendant did not specify whether he was proceeding under the Sixth Amendment or Article 1, Section 10.
When you don't specify and you just raise right to counsel, don't we have the right to look at it under both, under our preservation rules?
Well, maybe, but this case is a little bit different from that because not only did he not specify, but he cited only Padilla, which is obviously a federal case. The district court relied solely on the Sixth Amendment in its order, and the defendant has relied specifically solely on the Sixth Amendment in his appellate brief. So even if it could be minimally preserved by not specifying in the by this point, it's certainly been waived on appeal.
Well, even, assume that the Iowa Constitution's preserved. I read Green, there's a distinction between the accusatory phase and the investigatory phase. And in Green, there was no right to counsel because we said it was still the investigatory phase. Where were we here when Mr. Saeed advised Mr. Hernandez-Ruiz to go to get a driver's license?
Well, you would be in the zero phase. I mean, there is no, predates even the investigatory phase. At the time that he was advised to go to the DOT, he was not even on the state's radar. There was no state involvement whatsoever with his, he of course hadn't been charged. He hadn't even been pinged by the software at the DOT yet. And so there is no phase. And that's,
Well, there's a phase, isn't there a phase that he was in jeopardy with respect to his freedom in terms of his immigration status? Doesn't that count? Shouldn't that count?
No, Justice Hecht, with respect, I think that, for one, the Iowa Constitution, of course, wouldn't apply to a federal removal proceeding. And federal courts have repeatedly held, including the Eighth Circuit, that there is no right to counsel in removal proceedings. And frankly, even if they were to hold that you have a right to counsel in removal proceedings, that wouldn't provide him a remedy in this case. The Supreme Court has held that the right to counsel is offense-specific. That's in McNeil versus Wisconsin and in Texas versus Cobb. And so,
But the problem here is that the immigration case is intertwined with the state prosecution. I think you may be right under the Sixth Amendment, but setting aside your preservation claim without deciding it, it seems to me, number one, under the Iowa Constitution, there plainly is a right in an immigration-type proceeding to the immigration proceeding is intertwined inextricably. I mean, you just can't separate them. But when you have a state prosecution for what amounts to a crime of moral turpitude, it has obviously it's linked and intertwined with the immigration case. So isn't it a little trickier maybe because of the interplay of immigration proceedings and the state court proceedings?
with all due respect, Justice Appel, I would strongly disagree both that the Iowa Constitution envisions a right to counsel in an immigration proceeding, and also that...
Well, because it's a federal, I mean, I understand it's the immigration proceedings is exclusively federal, and I guess
Right.
one of your claims is, I gather, is because it's exclusively, it's federal venue, federal jurisdiction, 100% federal process.
Right.
That the state constitutional claim right to counsel has absolutely no application.
That's right.
I understand that. But surely it's a case involving life or liberty.
Well, whether it is or not, this case is not a case involving life or liberty. This is a criminal prosecution.
Assuming you separate them, right. I mean, I mean, your case, I think, and I do invite you to push back on everything, as you know.
Right.
You are separating the two proceedings, and I understand why. You're saying, well, we have the state court proceeding over here, we have the immigration proceeding over here. We just look at the state court proceeding, and if you just look at the state court proceeding, I understand you're saying, gosh, the guy shows up at DOT, there's no, the forces of the government haven't been, the clouds aren't assembled when he walks in the door, at least.
Right.
As to a DOT-type violation. But on the other hand, the storm clouds are clearly out with respect to his immigration status. And I don't think you disagree with that. But what I hear you saying is you just need to drive a wedge between the two proceedings, separate them, and I understand that, but I'm wondering, golly, is that really what's going on here? I think you understand.
Yeah, I understand your question, but I think that it's very important to point out that we're not driving a wedge between these two proceedings. They are, in fact, separate. One, is a federal, under the federal Constitution with the United States government, and this is a state prosecution. They are completely separate, in fact. And furthermore, there is no way for this court under the Iowa Constitution to provide the defendant with a right to counsel in his federal proceeding. I mean, the idea that we would do that, you can imagine what would happen in that case. Suppose that he doesn't get one, or his attorney is bad, and he goes to the federal court and says, well, the Iowa Supreme Court says that I have a right to counsel and I wasn't provided one, so I want my immigration decision overturned. I don't think they're going to go for that. So really, I guess my point is, you do have to look at them separately, and you do have to look, in this case, specifically at the state prosecution. Now, as we talked about, under the Sixth Amendment, the Supreme Court has held that the right to counsel attaches only after the commencement of adversary judicial proceedings. And this court has sort of a flurry of decisions decided in the 80s, and then, of course, with Green.
If that's true, why do you get a right to counsel with a Miranda warning? I mean, that's based partially on the Sixth Amendment. That's pre-charging. That's in the investigatory stage. Is Miranda just wrong then?
Well, I mean, Miranda is obviously, more based on the Fifth Amendment.
If you read Miranda, it says Fifth and Sixth.
Justice Harlan thought it was more sixth.
Well, that may be the case, but I think that, Miranda is clearly dealing with the investigatory stage, and we don't have a Miranda claim.
It's also
in this
Miranda
case.
is when the person's in custody, right?
That's right.
This person wasn't in custody when he was sent to go to DOT allegedly to get a driver's license, or apparently that's the finding of the district court, right?
Exactly, and Miranda clearly doesn't apply to this case, and to the extent that your question is addressing whether Miranda suggests that the Sixth Amendment is not exclusively more of a trial-type right, I think that that's been answered by the Supreme Court's other cases.
If we recognized a right to counsel under this situation, where would it end? Anytime a lawyer gave bad advice that led somebody into being charged with a crime, do they have a defense to the crime because they had bad advice?
To be honest, Justice Waterman, in order for the defendant to win this case, I think you have to say that the right to counsel attaches as soon as you've completed a crime.
On have a lawyer. I mean, one of the points they're trying to make here is that this is different from the scenario just described. Namely, a lawyer is present. And, I mean, it's more akin to the situation where a person is being interviewed by the police but is not in custody, and the lawyer shows up and wants to talk to his client. And there might be some dispute as to whether that lawyer has a right to talk to his client. Not in custody, so Miranda, let's just stipulate the doors are open and da-da-da, but the lawyer's out in the ante-room and they just say, no, can't come in. Here, the high water mark, I think, of the other side's position is he had a lawyer, actually had a lawyer in place. It's not like we're looking for a court-appointed lawyer or anything like that. And isn't that a significant fact?
I don't think so. I don't think that you can control when the right to counsel attaches simply by hiring an attorney. I mean, you can imagine a way that you could insulate yourself from prosecution by robbing a bank, hiring a lawyer, and then having him stand on the street and say, my client robbed a bank. That would certainly be bad lawyering, and if that's ineffective assistance of counsel, all of a sudden you've told the state you can't prosecute this person based on what their private attorney did. I mean, the idea is that if the state is going to prosecute you, we're required to provide you with counsel, and if we provide you with ineffective counsel, that affects that prosecution. The fact that you have your own attorney and he gives you good or bad advice is simply not chargeable to the state. In most cases, I think after Green, the adversary judicial proceedings are going to commence generally with the filing of a trial information. Obviously, there are situations where it may be earlier than that, when there's a firm commitment to prosecute. We certainly didn't have that in this case. The trial information was not filed until May of 2012, whereas this advice was all given back in March. So the state believes that there was no right to counsel at the time, therefore he cannot prevail on an ineffective assistance of counsel claim. If there are no further questions, I would ask that you reverse the decision of the district court.
Thank you, Mr. Ogden. Ms. Hanson.
May it please the court. Your Honors, good morning. My name is Maggie Hanson, and I represent the appellee, Guillermo Hernandez-Ruiz, in this case. The state has framed this case as an issue about the right to counsel, a right to counsel under the Sixth Amendment of the U.S. Constitution as well as under the Iowa Constitution, and that's explicitly set forth in the state's briefing, the appellant in this case. This is not a case about the right to counsel.
Well, before you go any further, let's talk about that a little bit. Mr. Ogden has taken the position that a claim under the Iowa Constitution is not preserved. Do you agree with that?
No, Your Honor, respectfully.
And how was that claim preserved?
First of all, Your Honor, I believe that the state has preserved that issue by raising it in their in the appellant's brief before this court, as well as in our briefing, we have disputed cases that the state cited that were state cases involving the Iowa Constitution.
Well, I may have misread the record, but it looks to me like when Mr. Ruiz filed his initial PCR application, he put a check mark on the application form suggesting that he was making a claim under the Iowa Constitution. Is that enough?
Yes, Your Honor, I believe that is enough. We raise the issue and we leave that open then for the courts to talk about both the Sixth Amendment as well as the Iowa Constitution.
Do you agree with Mr. Ogden's characterization that the district court did not decide the Iowa constitutional issue?
No, Your Honor. I believe the district court distinguished some of the Iowa cases involving the Iowa Constitution, which the state had cited and that the Polk County Attorney's Office cited during those proceedings.
Okay.
Well, even assuming it's preserved, isn't there what I'll call a mix and match problem? I mean, you heard the argument, but you've got a federal proceeding over here, you have a state proceeding over here. There's no evidence in the record of any I don't think. I mean, there's no evidence of any kind of cooperation or collusion between the federal and state governments here. Your client walks in the door at DOT. At the time he walks in the door, the forces of the state, the powerful prosecutorial forces of the state that require a lawyer to balance the contest, have not gathered at all, really. I mean, he walks in there. Now, it may have been bad advice to go, but does that really raise a problem of ineffective assistance?
Respectfully, Your Honor, I do believe it raises a problem of ineffective assistance of counsel. A lot of the cases that the state cites, including both Sixth Amendment cases as well as state cases, involve the express case where we don't have counsel. Someone's seeking the appointment of counsel, the right to have appointed counsel. Here, we're not talking about that right. We're talking about someone who already has counsel.
Yeah, but if I'm the lawyer and I'm giving advice, and my client comes in and says, well, let's say my client's a banker, and I say, well, go ahead, give the preferential loans to your buddies. I think that's fine. I don't think that's, well, it is not fine, I will tell you, and it could lead to some criminal liability. So I give bad advice. Let's just stipulate to that, bad advice. But the client goes out and engages in the very conduct. That doesn't give you a basis for attacking the conviction, does it?
What I would say, Your Honor, is that we talk about in our briefing the case of the Bowers case.
Yeah, but the Bowers case, the prosecutorial powers were absolutely assembled. And we have a division on the court of when the right attaches. I do not think it attaches upon the filing of a piece of paper in all instances. I think it goes back to situations where the trial would be fundamentally affected. But even with my more expansive view, generally, I think our cases have suggested, and the more expansive cases suggest, that the power of the state has to be at least focused, using Escobedo, focused on the defendant. The whole purpose of the right to counsel is to lean back into the powers of the state. But if the storm clouds haven't gathered, I'm not sure you have a claim.
And we have an interesting case here, Your Honor, because we do have an intersection of both immigration and criminal law. We have someone, Guillermo Hernandez-Ruiz, who was already under the focus of the government albeit in his immigration proceedings. And although it was not the criminal proceedings necessarily just yet, he had hired counsel. He had hired Michael Said to represent him in those immigration proceedings.
Right, but it's probably true, and push back, I invite everyone to push back when I explore issues, but does the Iowa Constitution, does that apply in an immigration proceeding? I mean, we have different search and seizure law, but if there's a criminal prosecution in the federal courts, they're going to apply the United States Supreme Court precedent under Fourth Amendment. How do we, even assuming that under the Iowa law this would be considered a case involving life or liberty, how do we attach that in a federal proceeding?
And Your Honor, my argument is not that the right to counsel had arisen in the deportation proceedings, and maybe that's where some confusion arises. Our argument is that we have someone who is currently in deportation proceedings, someone where criminal convictions are, it becomes a bigger deal. It becomes a bigger deal to them because those criminal convictions, albeit in separate proceedings, can now result in the deportation of that person in their immigration proceedings. So we have
counsel, isn't your client's remedy a malpractice claim against Mr. Said? If he gave bad advice and that led to these bad consequences, doesn't he have that as a civil remedy?
Respectfully, Your Honor, I disagree. First of all, notably, he was in post-conviction relief proceedings, and by their very nature, the remedy in those proceedings is a vacation of whatever conviction he was convicted of. But in addressing your question, civil malpractice, those are monetary remedies. We have someone who now faces the harsh penalty of deportation, someone who's going to be exiled from this country, separated from friends, family, a job that he works at.
But here's the fact. There's kind of no dispute he actually did commit the crime. The ineffective assistance was in inadvertently alerting the authorities to the fact he did commit the crime, right?
I would agree with that, Your Honor.
Yeah. And so normally when there's a PCR and we find ineffective assistance, then you can go back and have a do-over with effective counsel. But that's not what the district court did. It said, well, this person gets kind of a free pass for a crime he unquestionably committed. Isn't that kind of unusual?
I would disagree with that characterization, Your Honor. What would happen now is it would go back to the district court level. Although we had vacated the conviction at the district court level, that's without prejudice. The state still has the right to bring that claim against Mr. Hernandez-Ruiz.
Wow.
But if you take your example, what if I'm a lawyer and a client comes in my office and says, I really haven't paid my state taxes for the last 20 years, and I'm really feeling bad about it. What do I do? And the lawyer says, well, go ahead and pay them, and hopefully you pay that and the penalties, and it will disappear. And I do that, and then I get charged with tax evasion. I mean, is that ineffective assistance of counsel so they cannot bring a tax evasion case? And if my remedy is a do-over, what kind of remedy is it? The guy committed the crime in your case, and what kind of hypothetical?
I believe the remedy, if we're going back to the district court level and allowing this defendant now to litigate their claim, we had a situation here where Said essentially offered him up to the DOT. He goes in, he signs a plea. There's no trial, no.
Hypothetically, you offer it up to the Department of Revenue.
And
it's the same thing. So every time somebody gets some bum advice from an attorney, or it might even be good advice, but it backfires, you can't be charged criminally, and that doesn't make sense to me.
But I think, Your Honor, what we have to glean from the Bowers case, and this is a case where the court was willing, albeit in the Sixth Amendment context, the court was willing to look past.
Well, but that's a little bit different too. My understanding of the Bowers case as well is that they sort of gave the attorney the option, okay, you want to have your client indicted, or do you want to be a witness against these other people? I mean, she's clearly, you know, even under your analysis and under your brief, she's clearly, in that case, a focus of the government. I mean, there's no focus of the government here with the advice that he gave to your client prior to that time.
But what we have here, Your Honor, is a situation where, although he had not been formally criminally charged, we have a situation where a client is relying on the advice of his counsel that he had retained to represent him in immigration proceedings, but then by the transitive nature of this, he has to represent him in criminal proceedings as well.
Ms. Hanson, so at what point in time then did the constitutional right to counsel attach under these facts?
What we would argue, Honor, is that the right to counsel ought to have attached at least at the time that Said told Hernandez-Ruiz to go to the DOT. That's at the time that the advice of Said set in motion a chain of events that ultimately led to both the criminal charge as well as the criminal conviction of our client. That's the rule we can take from Bowers. Bowers, we have someone who has...
But Bowers, again, Justice Zager raised a good question. I'm not sure you answered it. I mean, in Bowers, there was a plea offer conveyed that was not passed along to Bowers. And so the court said, well, you know, it's against the weight of authority, but at least, you know, it seems to me more in the ballpark than this case. In that situation, the state had or the federal government had actually focused on the defendant, conveyed a plea offer. This was well beyond investigatory stage. They knew about the crime. It wasn't like this DOT situation. I mean, isn't Bowers a different case?
I do agree, Your Honor, that Bowers presents a different factual scenario, but what I do think we can take from Bowers is that the courts are willing to move prior to that formal initiation of criminal proceedings. We're talking about situations prior to indictment. They're willing to...
Let me give you another example here. Say someone is in state court and they plead guilty to a drug charge, and for some reason the judge decides to give them probation or deferred sentence, and someone doesn't like it. Now he did it on advice of counsel. Now they bring a federal charge. And under the federal sentencing guidelines, it's a 10-year minimum. I mean, is that in effect since the counsel telling someone to plead guilty to a state charge because you may be in jeopardy of a federal charge?
Your Honor, if that was not explained to the defendant at the time that the plea was made, then I do think that would be grounds for an ineffective assistance of counsel claim, potentially.
But here we're going all the way back. You know, I guess this is where I'm having a little bit of trouble with this. We're going all the way back to, and it's really a non-disclosure rather than actual advice. I don't know that he told him to go out, and maybe he did. I can't remember. I thought in some of the deposition testimony, he just simply said, I wasn't going to tell him not to go. So I don't know if it's a non-disclosure or a actual active advice to him. But this goes all the way back to prior to any government involvement in this at all, other than the federal obvious immigration concerns that are there. And so I see this as being so attenuated from an actual post-conviction, and then you really got to go a long way in my mind to finally get to the actual plea and sentence in this matter, which would bring you under the post-conviction. So just explain to me how we get clear down that path.
Certainly, Your Honor. What I would say here is that we have a situation, it differs from some of the situations we have in the case law presented before us. We have a situation here, and I've reiterated this again and again, I know that we have a situation where someone has appointed or has counsel retained. And we get to that point because we're talking about a situation where this person doesn't have while we're not talking about a situation where the government forces are necessarily bearing down upon him at this point, we had such a short amount of time between the time he was sent to the DOT, and for clarity's sake, Michael Said did provide him direct advice to go to the DOT.
Is it important in this case that he had counsel retained already before the advice was given? What if, I mean, if we're just trying to decide when does this right attach, if a person is wondering whether their conduct has criminal consequences, so they go to a lawyer to get some advice, is I have this plan on how I'm going to buy and sell mortgages in the business world, and I want some advice on whether or not that's legal. When an Iowan or someone goes into a lawyer for that advice, do they then have a right to counsel where if they're indigent, they're going to come into the court and say, I need a lawyer to advise me whether or not my conduct is going to be criminal? Is that where we're taking this?
I do think we need to state that, consistent with what we'd take away from Bowers, that in the situation where we have a criminal threat, whether it be someone who intends to commit a crime or has already committed a crime but maybe hasn't been charged yet, they seek the advice of counsel, and that counsel's advice is going to have an impact on their life and or their liberty. I think that's a case where we have to say that the right to counsel has attached. Now, this is a very narrow exception. It's a very narrow situation that we're asking this court to look at. It's not asking for an expansion of the right to counsel, and we're not asking for an expansion of the responsibilities of court-appointed counsel in this case. Your Honors, I see that my time has expired, and I'll just briefly conclude. This is not a case about right to counsel, as I've stated, as Guillermo Hernandez-Ruiz had hired counsel who he hired for his expertise in both criminal and immigration law, counsel who, with the knowledge of Ruiz's prior crimes, sent him to the DOT, essentially offered him up to be charged and ultimately convicted of the crime of fraudulent practices in the 4th degree, a crime of moral turpitude, which forecloses his removal proceedings or his cancellation of removal application. It cannot be that an Iowa judge cannot vacate an Iowa conviction based on the actions of an Iowa lawyer. Accordingly, Your Honors, for the reasons discussed, Appellee asks that you affirm the district court's grant of post-conviction relief to Guillermo Hernandez-Ruiz. Thank you.
Ms. Hanson, thank you as well. Mr. Ogden, you may present your rebuttal argument.
The appellee frames the case as being one about remedy, basically. The remedy of money damages in a malpractice action is insufficient to redress the grievance that he has against his attorney. And maybe that's the case. I think you could argue that money damages are insufficient emotionally for a lot of things that they are in fact the only remedy for. When you hire an attorney in Iowa, certainly that attorney is required to abide by professional standards and can incur tort liability for basically what I guess you would call civil ineffective assistance or malpractice. And that is the recourse that's available to the defendant in this case. I want to take just my last minute or so to say a couple of things about Bowers.
Before you go into there, is there any hint of any claim in this case that his attorney was ineffective for pleading him down from 4th to 3rd?
Not on appeal, no. That was a part of the application for post-conviction relief, and the district court held ineffective because it was basically the best deal that he could get, his best hope at avoiding serious immigration consequences at the time. So about Bowers, I want to be very clear, because I've sensed a sort of mood about the case. The state's position is that Bowers was wrong. it came about in this weird kind of middle ground between Kirby and Gouveia, where you had a plurality of the court that had held that the Sixth Amendment doesn't attach until adversary judicial proceedings, but it wasn't confirmed by a majority until Gouveia a couple years later. The fact that there was significantly more prosecutorial involvement in Bowers is one reason to distinguish the case, but it's far from the only thing that is troubling about reliance on Bowers. In addition to the fact that it predates Gouveia, it's a district court decision that was not appealed, and if you read the opinion, it doesn't appear that the issue of when the right to counsel attaches was really challenged by the federal government in that case.
Let me come back at you on this and use some of the themes that's used by the opposition. This isn't a right to, the question in this case isn't attachment of anything. Counsel was present. I mean, counsel was retained. The real question is, at the time counsel gave advice, was there a case involving liberty? You don't get a constitutional right absent a case involving liberty. One argument might be, well, there is no case involving liberty because a piece of paper hasn't been filed at the courthouse. I mean, that, you know, kind of stricter rule. Another argument might be, well, there is a case involving liberty where, in Escobedo, the focus is on an individual. The argument, I think, advanced by your opposition is that, well, although it's a kind of a federal proceeding, I mean, there's a mix of kind of federal and state proceeding, at the time that the client is sitting in the office, was there a focus of government forces on him? And I think their answer to that question is yes. I mean, isn't the real question, though, whether is there a case involving liberty?
Respectfully, no, I do not think that's the question. Under the Iowa Constitution...
We're not trying to attach anything, though. I mean, it's not a matter of attaching anything. Counsel is present.
I understand that, but under the Iowa Constitution, there is no case. There's no case involving liberty because the federal proceedings, they don't exist for purposes of the Iowa Constitution. It doesn't apply to the federal government. And as Chief Justice Cady made clear in Green, when you're talking about a criminal prosecution, you're not talking about cases involving liberty. You're talking about an accused facing prosecution.
Well, but the Iowa Constitution has two separate, I mean, you know, as you know.
Right.
Prong one of the Iowa Constitution deals with criminal, and part two deals with cases involving liberty. I mean, in the most abstract sense, I suppose. I mean, I understand it's quite abstract. But when the client is sitting in the office, this guy's interests in liberty are certainly in the room. Now that, you know, in the room may not be a quote case, but on the other hand, they're there, and it strikes me that the right analytical framework may well be, you know, where do you draw the line of a case? I mean, a case is not amorphous. I mean, a case has to have boundaries of some kind. And the real question is what package is there in a case? And I guess at a minimum it's true. Those interests are in the attorney-client conference, are they not? I mean,
with your leave, Mr. Chief Justice, I'll briefly answer the question. As far as the Iowa Constitution is concerned, the case involving liberty has to be a case that is brought, instituted by, gathered up by the state of Iowa. Otherwise, you could have a prosecution pending in Montana, and you would have all of a sudden a right to counsel in Iowa based on that case. That can't be the rule. The district court ought to be reversed. Thank you very much.
Counsel, but with all due respect, wasn't that scenario of disparate sovereigns, the central focus of the discussion at the Iowa Constitutional Convention debates. In other words, you had at interest in that argument a fugitive slave present in Iowa who is being chased by a different sovereign other than Iowa. I mean, granted, we have different sovereigns here, the federal and the state, in different proceedings, but wasn't that sort of what was going on in the fugitive slave context?
With your leave, Mr. Chief Justice. I think that's right. I think that the fugitive slave context is obviously a unique set of circumstances. I don't think that the framers of the Iowa Constitution envisioned that idea being extended to any involvement from a different sovereign. You know, they were dealing with a very particular case. So that's how I'd answer that. Thank you.
Mr. Ogden, thank you as well. The case of Guillermo Hernandez-Ruiz versus State of Iowa is now submitted, and the bailiff may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.